Thank you. Prince Pugh, state what you please for the record.
Yes, Your Honor. Thank you. This is State of Indiana versus Prince Pugh. Cause number is 64D01-2305S64448. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Pribble. State of Indiana by Gary Gurman.
Morning, Mr. Pugh. Can you hear us okay?
Yes, now comes the respondent, Prince Pugh Bay, a national state citizen through the United States of American Republic, a sovereign government that has its own jurisdiction.
Yeah, Mr. Pugh, you keep filing things with the court, and you can't file things with the court because you have a lawyer. We don't.
I object to any counsel on my behalf.
We don't permit hybrid representation. You have a lawyer that's been appointed for you. Anything
I object to any counsel.
Him. If you keep talking over me, I'm going to hold you in contempt. Do you understand me?
No, I do not.
What don't you understand?
That I object to any counsel and that you're denying me representation pro se.
You've never requested to represent yourself, sir.
Since day one, I represented myself pro se with all my filings.
You have never once requested affirmatively to represent yourself. You've
Since
never
day one on the record
to represent yourself, sir.
Yes, since day one.
Not a single time. I'm telling you right now.
Since day one, I fired the attorney. I haven't.
If you want to make a proper motion to represent yourself, you need to do that. But you have not done so, sir.
I have filed it. Did you go over my documents?
I see the documents that you file, and because none of them ever asks for your ability to represent yourself, I strike everything from the record because you have counsel and we don't permit hybrid representation. It's that easy.
Do you have a written order of those strikes so I can appeal?
Your Honor, may I interject for just a minute, please?
Go ahead, sir.
On June 12th, Your Honor, I did file a motion for leave to withdraw. In that motion, I did attach an affidavit from my meeting with Mr. Pugh. In that affidavit, he does specifically and clearly state it is his desire to represent himself pro se. He acknowledged his constitutional rights. He acknowledged his FREDA warnings, but he did make that request.
Thank you.
He made that request in an affidavit in your motion to withdraw.
That's correct.
Okay, he needs to make an affirmative request of his own directly to the court that he would like to represent himself. Upon so doing, I will hold a FREDA hearing like I do every other time. Until that happens, I'm not going to hold a FREDA hearing.
I object.
Sir, you can object all you want. That is my ruling.
Well, I object.
To ask for the ability to represent yourself, you need to do so affirmatively. If you want to do that right now, I will listen.
Any objection?
All objections.
That's all.
I object. He just stated to you that I specifically and clearly motioned to represent myself since day one.
Well, then
he just said that on the record.
You have not, sir. You have not.
The court has yet to identify its status of jurisdiction.
Sir, that is absolute nonsense. I don't even know what you said. All right?
I said the court has yet to identify the status of jurisdiction.
Represent yourself. You have to make.
If you clear the bias out your ears and out your eyes, then you can hear what I'm saying. The court has yet to identify the status and legal jurisdiction. I'm a Moorish American national through the United States of American Republic, i.e. a Native American.
Or you wouldn't be sitting there in jail right now.
I'm a Native American. It's called due process, but this is a gross due process violation, constitutional violation, as well as civil rights violation.
Mr.
A judge cannot sit in authority over a foreign state citizen.
This is another contempt warning. If you talk over me another time, I'm going to find you in contempt and I'm going to sentence you to up to 6 months in jail. You understand that?
No, I do not.
What don't you understand?
I don't understand how I'm representing myself and you're cutting me off on the record for stating
you are not representing
on my behalf.
You have appointed counsel, sir.
I object to any appointed counsel.
On May 25th, 2023, you sat before me and requested the appointment of counsel.
I
I
object.
appointed counsel based upon your request. Since
I
that time,
object.
you have not affirmatively requested to represent yourself before this court. If you want to do so, I will hold a Ferretta hearing. If you do not do that, I will not hold a Ferretta hearing, and Mr. Pribble will carry on as your attorney. Do you understand?
No, I do not.
All right, sir. Then this case is adjourned. I will see you back next Friday, and we'll continue to have hearings every Friday. I've got
Yes.
you under a contempt warning as well. And if you continue to say you don't understand when you clearly understand, then I will hold you in contempt for that as well. Do you speak English?
I don't understand
Do you
how
speak
you can
English, sir?
force,
You answer my questions.
how you can enforce.
Sir, my questions before I let you talk again. Do you speak
He's a genius.
English?
I speak Moorish American.
Okay, sir. Whatever that is. All right, Mr. Pugh, we'll see you back next Friday at 9 a.m. We're adjourned.
Thank you, Fish. Appreciate you.
Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this motion to revoke probation hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary, Mr. Allen?
Yes, sir.
In summary, this motion, which was filed October 30th of 2025, in summary, it states that on August 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of deadly conduct by discharging a firearm. Is all of that true and correct, sir?
Yes, sir.
Allegation 1 states you committed the offense of driving while intoxicated, I guess operating a motor vehicle while intoxicated, a DWI,
Yes, sir.
on or about October 4th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state. Is that allegation true or correct, sir?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, Your Honor.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be found guilty and you can be sentenced to no less than 2 nor more than 10 years confinement in prison under this third-degree felony. Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let's see, I'm looking at number 2 is failed to never become intoxicated. Do we really need that one? We've got the DWI.
State's willing to abandon that, Your Honor.
3, failing to provide verification performing community service hours.
I'd like to leave that one in, please, Your Honor.
All right, number 3 states you failed to provide verification of performing community service hours. And according to the administrative hearing filed by the probation office to support the filing of this motion, it states that you were assigned 600 community service hours. You completed 276 and have 324 remaining. Let me ask on probation. Was he doing okay on community service hours? He didn't complete them, but he was only on probation for a year.
Yeah, he was always almost at his halfway mark, Your Honor.
Well, okay, he was at his halfway mark on what?
Community service hours.
Okay, and he was on probation for 10 years, but he had only been on probation for a year, right?
That's right.
So he was about 10% of his probation time, but he had served He had covered half of his, that's pretty good, isn't it?
Yes, Your Honor.
Okay, I'm not gonna punish him for that. It sounds like he was trying. We're gonna be okay on that one. Can we abandon that?
Judge, if the court's inclined to find it not
Well,
true, then I
yeah,
don't
because-
necessarily want to abandon it.
But,
Judge.
but where was he on, I mean, was he didn't complete it, but was he caught up?
He was almost caught up. Yes, sir.
Well, I'm not gonna punish it.
If the court's inclined to find it not true, then that's fine, Judge.
All right. Number 4.
We'd like to keep number 4 and abandon number 5 with regard to the fees, Judge.
4 states you were at a location other than your residence at approximately, it says 23:49, that's military time. I presume that's 11:49 PM on or about October 4th, 2025, in violation of condition 18 of your probation order, and 18 of your probation order states that you must be inside your home every day between 10 PM and 6 AM, except for employment purposes. So that was about 2 hours outside your curfew. Is that true?
Yes, sir.
Are you pleading true to that one? That violation true because it is true as it is alleged.
Yes, Your Honor.
And I've already told you that unknowingly and voluntarily made plea of true to one or more violations, that would be enough to grant a motion to revoke probation, and your probation could be revoked. Do you understand?
Yes, sir.
No. And we're abandoning 5.
Yeah,
So
Your Honor, with regard to the fees.
let's
The state has a brief argument.
hold on. We've got
witnesses.
we've got a second case.
We get to argue. No?
We've got a second case to deal with
I
too.
think they've got the same mirror allegations, Judge.
Mm-hmm.
Well, we got to pick them up.
Okay.
So 24 CR 304 is called the State of Texas versus Philip Lawrence Bennett, who is the defendant. And in this case, there's a motion to revoke probation filed as well as of October 30th of 2025. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
All right. And again, you're still under oath in this hearing, so remember that. All right. In summary, this motion to revoke unadjudicated probation states that on August 27th, 2024, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation, as well as in the previous case for the 304 case of deadly conduct discharging a firearm, a 3rd-degree felony. Is that true?
Yes, sir.
And
State abandons allegation number 2, Judge.
allegations 1 and 4 are the same as what you have pleaded true to in the previous case, committing the offense of driving while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and 4 at a location other than your residence at approximately 11:49 PM on or about October 4th, 2023. And those are violations of conditions 1 and 18, respectively, of your deferred or unadjudicated probation order. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those
Yes, sir.
voluntarily and because they are true as they are alleged?
Yes, sir.
And again, you are understanding that a true and correct violation of one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. In this case, it's the same as the previous case in the motion to revoke probation. You were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Knowing all of that, do you insist on pleading true to allegations 1 and 4 in this cause number 24 CR 304 in this motion to revoke probation, as well as the previous one?
Yes, sir.
I find you are pleading truth voluntarily, knowingly, intelligently, and there is enough to grant these motion to revoke probation, enough evidence by a preponderance of the evidence or greater to support the motions to revoke probation. What are we going to do?
Judge, it's a cap of 5, and I got 2 witnesses I want to call.
And go ahead.
All right, I want to call a probation officer as the first witness. All right? All right. Did you have a-
Hold on. And raise your right hand, sir. Do you probation? But I like your vigor in raising your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand and go ahead.
Will you state your full name for the record?
Jesus Ruiz?
And Mr. Ruiz, you were the probation officer in this case?
No.
Okay, who you covering for?
Joseph Champ.
All right, so you're covering for Mr. Champ. That's fair. That's no problem.
Oh,
So-
hold on. Are you familiar though with these files to be able to speak intelligently about what's in them?
Somewhat familiar, yes, sir.
All right.
So basically what Judge said, you had a chance to review all of the notes of Mr. Champ and everything that he's done in this case.
Yes.
All right. And in doing so and reviewing Mr. Champ's notes, you understand that my client was placed on probation on the 27th day of, well, he was placed on probation specifically. This order was entered on 10/30 of 2025. That's the date that I see this file stamp. All right. All right. And let's deal with one of the allegations that was abandoned. And I think that that's positive for my client. You understand the judge pointed out that in terms of his community service, he's placed on probation for 10 years, right?
I want to be clear, the state didn't abandon that allegation.
Yes, you did.
No, I did not abandon the allegation about the community
Okay.
service. I welcome the court to find it not true if he was so inclined, but I didn't abandon.
Okay, well, at the bottom line is that would you, in terms of failure to provide verification to community service office, you do know that he's done over 50% of his community service?
Not 50%.
How much has he done?
276 hours.
Out of how many?
600. 50% will be 300 hours.
Okay, so he's pretty close.
Very close.
So as it relates to providing verification, you do know that he did do the 200 and what?
76.
And do you consider that doing pretty well?
It's pretty well.
That's pretty well. And is that better than most people who's on probation?
I'm not sure.
What are people who you supervise?
They tend to meet the halfway mark.
Okay.
And 93% are successful.
All right. The next point that I want to make to you is that in addition to doing his community service on his arrears, I noticed that these arrears is just $308. Is that right?
Yes.
Right. So he has been making payments while he's been on probation. Is it right?
Has been making some payments. That's it.
Well, not just some. I mean, at least according to what I got here, total credit 1,112 is what I read right here for the total credit as payments.
Yes.
Right. So he's not just making some payments. He made at least 1,112. I mean, so he's making payments, right?
Yes.
And I see that he's periodically making $60 payments, $155, of $115, $105, $85. So he's making regular payments.
Yes.
Right. And that only left him with arrears of 308, right?
Yes.
Right. And in doing these cases, I've seen people that's $1,000 in arrears, right?
Yes.
So as another positive about my client, he's making payments and he's also ahead of the game in his community service. That's a positive, right?
I don't know about ahead of the game, but he's on his way. Yes.
Okay. Also, as it relates to the nature of the offense that the state is going on for this October the 4th, you did get a chance to look at Mr. Champ's notes and administrative hearing. In terms of this DWI, this is not a DWI where we got an accident, somebody's injured, a DWI where somebody is a danger to the road. This is one where he is in a parking lot parked and the underlying, and you can look at it if you don't, just refresh your under findings. They had administrative hearing and he's basically, have you seen this?
Yes.
Yeah, he's basically in a parking lot parked, right?
Mm-hmm.
So he's not driving a car at that time. Is that right?
No.
Right. And so in terms of the seriousness of this particular offense, this isn't a DWI where you got a wreck, somebody injured, he's on the road, he's in the parking lot sleeping. Is that right?
Yes.
Now, the judge has mentioned about the success rate of the probation department in terms of programs that you can provide for him that he's admitted to on the driving while intoxication on October the 4th. What programs does this probation office provide for people who have some alcohol problems? Do you have any programs?
We have substance abuse assessments that we provide. We do have programs, yes, sir.
And at the time of this offense, was he getting any of those substance abuse treatment?
I am not sure.
Okay. And if he's continued on probation by our judge today, could the judge order him to take the substance abuse treatment while keeping him on probation?
That's his decision.
Actually, could he do so? And the answer would be yes, he could, right? All right. Now, how do you feel about that substance abuse treatment program? Do you think it's a pretty good program?
It is a pretty good program.
How well is it? How would you describe it?
With my clients, they've had pretty good success.
All right. So do you have any reason to believe that if he's continued on supervision and he's put into this program that he would not be successful?
I'm not sure.
All right. But you
I don't know the client well enough.
I got you.
To make that decision.
But in going through the notes of Mr. Champ, you don't see nothing that would say he wouldn't be successful, would you?
No.
All right. So in addition to the programs that you provide in your department, which is the substance abuse, how about in the community as a whole, Jefferson County? Do we have programs here to help people with alcohol, like AA, right? So not in addition to the programs that he would have access to through your department, which is in the community as a whole, we would also have access to those programs, right?
Yes.
So if the judge with this 5-year cap offer continues him on supervision, he could be in those programs and not be a danger to anybody in the community. Is that right?
I don't know about that. I could be in the program and still be a danger.
Well, you could be a danger to somebody today.
That's argumentative.
No, well,
State objects. That's argumentative.
Sustained.
But at the end of the day, anyone can be a danger at any particular time. Do you understand that?
Yes.
All right. So in his particular case, if he has the program that you just bragged about, if he has the access in the community and he's doing what he's supposed to do, he can probably continue to be on probation and be successful. Do you understand that?
Yes.
All right. And the probation department can meet all of his needs that need to be met. Is that right?
Yes.
By continuing him on supervision. All right. Last question for you, and here's where I'll stop. I know you said that you were not the supervising officer, but in reviewing Mr. Champ's notes, from reading his notes, what are the positive things you can say about my client from your reading of all of his notes?
That he was somewhat compliant with his probation. He was going to office visits. He was doing pretty good on this community service, and he was meeting his payments.
Okay. And did Mr. Champ express any feelings to you about this particular case? So when you covered for him, you basically took the file, but you didn't talk to him about as to what Mr. Champ's recommendations were, right?
No.
All right. So you're not prepared to give a recommendation today. That's more for Mr. Champ.
Well, he's retired. So,
Well, he's retired. Well, he can't now, but I'm saying he's not here
yes,
to give a recommendation because he's the main one, right? And what you say that you can't do because you're not the one who supervised. All right. Pass the witness. Thank you for your time.
If I may, Your Honor, I'd like to direct your attention to the administrative hearing and the report or the document from that hearing dated October the 6th of 2025, particularly the findings. And if you need to, just take a quick look at it to refresh your memory of that or recollection. Oh, just tell me when you're ready.
all right.
All right. Particularly with regard to these highlighted portions of the findings, when the officer or officers encountered the defendant with regard to the DWI arrest, where was he located?
He was in the middle of the parking lot
Where?
at Taco Bell.
And did other vehicles have to go around him?
Yes.
And it was indicated that when law enforcement made contact with the defendant, what state or condition was he in?
He had thick saliva running out the side of his mouth.
And eventually, the officers, how did they get the defendant to awaken or or respond?
They have to be on the driver's side of the vehicle.
Okay. That's all. I pass the witness.
So basically, in what you said, I mean, people don't speed in parking lots, right? I mean, you shouldn't be, you shouldn't be. All right. So in terms of what he's in the middle of a parking lot and the saliva that comes out of mouth, I mean, the common term for that is drooling. I mean, that's associated with sleeping. You understand that, right? And at the end of the day, he's parked in a parking lot sleeping, and in that parking lot in Taco Bell, people drove around so they can get into the line to order their food. All right. So for purposes of continuing him on probation and how this question is relevant for the judge and continuing him on probation, out of all the kinds of DWIs you can have, this is not the most serious one. You don't have him drunk and killing somebody, drunk and getting into a wreck, drunk and hurting himself, drunk or hurting somebody else. He's sleeping in a parking lot. Is that right? Yes. Right. So, and that would be one of the arguments and basis for continuing on probation as it relates to the seriousness of the offense. Pass the witness and
Just one follow-up question, Judge. Based on your experience, your life experience, how do you surmise that this defendant got to that parking lot there at Taco Bell?
the objection, his life experience is irrelevant to the question. It's told whatever his life experience is not a relevant question for this case. His life experience is not material to this case.
Your Honor, the court can draw an inference. I'll move on.
Go ahead.
That's all I got, Judge. I got another witness. That's it.
All right. Let me ask a question here. I'm looking at all the papers. The agreed punishment recommendation here, a cap of 5 years.
Made by the previous prosecutor, Judge.
It says the sentence will run concurrently with the DWI. What DWI are we talking about?
The underlying offense.
I think it's in Judge Holmes, if I'm not mistaken. And he's going to handle that too and try to dispose of everything.
That's the underlying offense, the Taco Bell incident we're talking about.
Okay.
I believe
so there's not an agreement that this each of these would run concurrent. Each of these motions
they can run together.
That's not what this says. It says will not exceed a cap. Look what it says.
No, I believe
it doesn't. It just says the DWI. It doesn't say concurrently with the other.
I can add that. It was.
Is that the plan?
Yeah, that was the plan.
While I didn't negotiate it, Judge, I can understand that would be the intent of the parties.
Right.
Okay.
Right.
You want me to add that?
Yes, sir.
No objection, Judge.
Okay. This is 303. So what I'll do is we'll run concurrently with DWI and 24 CR 304. Good.
And that's
what we'll do on the other plea agreement. It will run concurrent. The 304 case will run concurrently with 303 on the other one. We'll make a change on the other one as well. Langston, okay?
Yes, sir.
Go ahead. Y'all go.
It will both line. This is Van Look.
Come on.
I don't have any more questions for you.
No, she's going to come up. He's going to have to see the bailiff. No, the bailiff makes the decision when they're in custody. He can sit right there though. He'll be present, or he can sit in the witness chair.
Well,
I don't care.
I don't even point. That's something new. I mean,
we don't do that. It's up to the bailiff's decision.
I don't know how that affects any substantive right of the defendant, Judge.
It doesn't. He's present.
Yes.
He's present. That's what's important. He's present. They don't have to stand next to each other for the law to apply. Go ahead.
Did you want to hear from him?
It's up to y'all.
Did you want to touch that? Yes, sir. All right. One question for you. You know that judge can put you in jail for up to 5 years.
How much time credit?
Put it up there.
Thank you.
The judge can put you in jail up to 5 years based upon the plea deal that we got with the state of Texas, or he can continue you on supervision. Speak on your own behalf now and tell the judge why you're asking to be continued on probation. You tell him.
Yes, sir. I really just was trying to make it back home to make sure I could take care of my grandma and my child as well. I mean, I was doing everything I was supposed to do. I was taking care of all of my fees and doing my community service, but like my mom wound up previously saying, I just wound up starting the job and I started putting more time into it. And I also have messages between me and my manager. Me and my manager would always talk. I was just putting a lot of time just trying to learn stuff, but I was going to become a manager. So I'd be making more money to provide for my family. And I wound up going through a little depression. And I also got the records from Spindle Talk. I could get those too as well. I just wound up going through a depression dealing with my first case. So.
What do you mean? Depression for your first case? I mean, you intentionally committed those acts. What are you, mad at yourself? You intentionally committed those acts. That's what you pleaded guilty to. What are you in depression for? You acted with intent to do that. So it's not like it was an accident or you were forced to by someone without your free will.
Yes, sir.
Don't be blaming something when it's your intent. You've got to stand up like a man, and actually that's what you did when you accepted responsibility the first time.
Yes, sir.
Because this was serious.
And you heard about from the probation officer when he testified about programs that are available to you. Did you hear his testimony, right?
Yes, sir.
And I asked him, think the program was pretty good. He said, yes, it is.
Yes,
that came from them, right? So if they have a pretty good program and he says that it's a pretty good program, your mama saying that she's going to do the transportation to get you there. The question I got for you is, if the judge keeps you on probation, will you do the program?
Yes, sir.
And will you be there and listen attentively and do what you need to do?
Yes, sir.
All right. So are you asking the court to continue you on supervision based upon what the court has heard from the probation officer, yourself, your mother, as well as your grandmother?
Yes, sir.
All right. And this time, if you got this one shot, you're not going to let it up and down, are you?
No, sir.
All right. Thank you for your time.
I have no question for this defendant.
Don't go anywhere. Anything else?
That's it, Judge. I just would ask the court to continue him on supervision, and I'm not going to rehash everything that you've already heard.
I'm sorry, please.
I'm not going to rehash everything that you've already heard. It's just listening to the mom, the grandmother. I really believe that they're sincere from their heart.
Hey, let me ask something before we finish up here on evidence in this case. I'm looking at.
Yes, sir.
This report on this event at 11:30, almost midnight here on October 4th. And it states, I requested Philip's blood, according to the policeman. Requested his blood. He consented. He also signed a DIC 24. I transported him to the county jail, checked the blood draw, ensured it was not tampered. It was not tampered. Draw was made at a little after midnight, about 1:00, and he was released. I placed the blood evidence in the blood evidence fridge. There's nothing in here that talks about what
we got the test back.
I don't have anything about the result.
If there's no objection from Mr. Adams, Judge, I tender to the court.
He came back.
I tender to the court the lab report indicating a 0.197 BAC from that evening.
Okay. Well, that's 2.5 times the legal limit of ethanol. So you were 2.5 times the legal limit at midnight when your family was at home and you should have been at home, right?
Yes.
Okay, give it your best shot.
Judge, like I said, you heard all of the testimony. I do believe, and I'm not going to rehash everything that you've heard, but I will give my commentary on that. I do believe that the grandmother, I do believe his mother is absolutely sincere, and they appear to be.
I'm sure she is.
And I don't know them personally, but just from my judgment of character, they really truly love their grandson, and I really believe that they're going to be there to help him do well on probation.
But they were there before.
Right, and as they testified, that that was an out of ordinary situation. With the probation saying that the treatment program, the substance treatment program is so good, I don't have any doubt that they're going to make sure he gets there. And I don't have any doubt that he's going to actually go there and get the treatment that he needs. And I think that Judge, if just from what I can tell about him, and that's just my position and argument, he doesn't appear to be one of those type of guys that needs to be incarcerated in prison, that's going to be a danger, that's going to be acting a fool. And I understand what's the underlying offense. I get you.
What about that?
No, I hate that.
Have you ever done such a thing? I haven't. I wouldn't even thought about shooting at cars and buildings.
Right.
At people where people can be shot and killed. Come on. That's
no.
He was, you represented him on the underlying case, right?
Yes, sir.
Yeah, you did a fabulous job on giving him a second chance in light of the potential catastrophe that could have occurred because there were numerous bullets shot. Yeah, that was a remarkable defense of getting him deferred or unadjudicated probation. And that's why, and you made promises to me, I'm going to follow these rules. And I stuck my neck out and gave you that chance.
And in terms of following those rules, Judge, I would ask to give him some consideration just on what the probation department said. In following those rules, he reported, he's doing that community service.
He's not getting punished for what he did do.
No.
Properly.
But
he's going to get punished for what he failed to do as required.
Right. But I was asked that the court would take that in consideration for mitigation purposes, because those were the things that he did well. And your probation department brought those things out. And the point that I'm making, Judge, is that I totally feel you on the underlying offense, but just look at it. I mean, he doesn't seem to me as that type of guy that
he's been in jail.
Well,
they don't let him have handguns in jail, and they don't let him drink.
No.
I mean, he's. But that's the problem. Is when he's in the free world, we have a problem keeping him from making mistakes and not following the rules. That's where you're not getting punished for good behavior. You're punished for failing to conform to what you were required to do, that you promised you would do. Follow all the rules.
I just think, Judge, if you give him this one shot, and I know you gave him first shot, which is probation. If you just give him this second shot, let's say that the second shot, I don't believe you'll see him again. And I just get that impression just from the support that he has for the family. I mean, you just think about this, Judge, and here's why I be quiet. Think about all of the people who come in your court, right, who don't have that family support and background. He does have that support. And I think that grandmother, and you can look at her, she appears to be a wise lady, years of experience and wisdom. And I think when they have that heart to heart grandmother, grandson conversation, if you continue him, I think after that conversation, the chances of him coming back is not going to be good. And I think that conversation is going to take place.
Most people in this room who are defendants don't have that kind of familial support and role modeling at home. He does.
Yes, sir.
Shame on him for having that environment, knowing right from wrong, and still making the wrong choices. Not one wrong choice, choices. You had role modeling at home. That was good. You go against what they were representing. You acted contrary to what their role modeling and examples were. And reminding you, what you tried to tell me a little while ago that I find disturbing is I've got family at home. You had a family at home at midnight when you were almost three times the legal limit of intoxication while you were on probation that forbid that kind of behavior. You should have been at home taking care of the family like you promised you would. And you were put in harm's way because you shot up the town that night and almost killed numerous people by shooting into cars and buildings. Next. What else?
That's all I got.
Yeah, I'll be brief because actually I had an outline of things I want to hit and I ticked them off as you mentioned them. The fact that probation was essentially a gift, you've mentioned that Mr. Adams was admirable in his advocacy in securing this probation for this defendant. I ticked off the fact that you mentioned that your order was a promise that this defendant made. What good is an order if you don't enforce that order, Judge, when it's violated? It's not a suggestion. It's not an invitation. It's not a pretty please. It's an order from the court, and this defendant, he violated that order. I ticked off the fact that you mentioned that it's his decisions. It's his decisions that put him before this court. There should be consequences for those decisions. And lastly, Judge, I also ticked off the fact that I was going to remind the court of the underlying facts surrounding the underlying offense and the fact that he's in a shootout with some other fellow and he's shooting at cars and buildings. And you mentioned that, so that makes my argument very brief, Your Honor. It is admirable that this defendant completed the community service hours he did. It's admirable that he was paying the fees that he paid, but nevertheless, there needs to be accountability, Judge, for violating the court's order. Judge, I go back to my time in the military when there was a phrase that was used called turning sharp corners. For this defendant to be given the gift that you gave him by putting him on probation, he should have known that the corners he turned, he needed to turn sharp corners, and he was cutting corners that night in that Taco Bell parking lot when he was intoxicated, Judge. And the court knows in its common sense that for him to get to that Taco Bell parking lot, he had to drive there, Judge. And in driving there 3 times the legal limit, he endangered the public like he endangered them during the shooting incident, Judge. 5 years is what I'm asking, Judge. I'm asking you to revoke this defendant and assess his punishment at 5 years, which is essentially on the low end or the mid range of the punishment range in this case, Judge. Mr. Adams made the comment that give him one shot, Judge. When does one shot turn into a second chance, turn into a third chance, turn into a fourth chance? He's making a mockery of this court and this judge's order.
No,
it's his argument, Judge.
No.
Hold on. Hold on. Let him.
How am I making a mockery of?
I didn't say you.
Hold on. Hey,
Mr.
one at a time. Break clean.
I didn't say he was.
Okay.
He gets a chance to be heard, and I'm gonna let you end. What else?
No, my point was the defendant was making a mockery of this of your order.
I thought you
Yeah, that's the way I understood.
Yeah, I thought he was saying I was. Okay, never mind. I take that back. I'm sorry. I apologize for interrupting you.
I'm asking you to sentence this judge, sentence this defendant, revoke his probation, reform his judgment, Judge, send him to a prison for the decisions that he made that brought him before you today. And I'm asking you to assess 5 years in TDCJ, Judge.
All right. Anybody else? Anything?
Judge, I'm just asking, and I'm not going. When you heard the argument, it's not for him, for his mom and his grandmother. Just please continue.
And you're right. I feel sorry for them. Why weren't they important to you at midnight when you were intoxicated on probation, when you had everything to lose? And they're but you made a promise to me that you would take care of things. And I stuck my neck out on this because these are 2 crimes of serious violence, which could have resulted in multiple injuries or deaths. On each of these cases, in 24 CR 303 and 304, where the defendant was placed on probation, deferred or unadjudicated probation for 10 years for deadly conduct, discharge of firearm, a 3rd-degree felony in each case. In this motion to revoke probation, I find that the defendant has pleaded true to allegations 1 and 4, committing the offense of operating a motor vehicle while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and being at a location other than his residence at midnight on or about October 4th, 2025. Those are both violations of terms and conditions of his probation. I find that his voluntary and knowingly plea of truth are enough in each of these cases to support those findings and allegations by a preponderance of the evidence or greater. I find them to be true, and thus these motions to revoke unadjudicated probation in each of these cases are hereby granted. In each of these cases, the defendant pleaded guilty voluntarily, knowingly, intelligently to the crimes of deadly conduct, discharge of a firearm, a third-degree felony in each of these cases. The defendant was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea in each case from State's Exhibit 1 to find him guilty beyond a reasonable doubt. His deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt in each of these third-degree felonies. And I am following this agreement. The agreement that was reached is whatever sentence shall not exceed a cap of 5 years. You being found guilty of these third-degree felonies, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years on each of these cases. These sentences shall run concurrently. Also, these judgments shall reflect affirmative findings that a deadly weapon, namely a firearm, was used in the commission of each of these crimes. Do you understand what has happened now, sir?
Yes.
Your probation is revoked and you are sentenced. And again, this court hates failure. I want to see success. I wish we had 100% rather than 93%. But you understood and appreciated the importance of the seriousness of this violent crime. We all stuck our neck out giving you a second chance. And it wasn't long, a year, and you are failing. And this was fixable. I think you're capable of doing the right thing and doing better. I'm disappointed because I had good ideas that you had fixed these mistakes and you were going to live better with better decisions. But once again, you have family and responsibilities at home at midnight. You're not supposed to be at midnight intoxicated, drunk in a vehicle, sitting around intoxicated while the family is at home and you're on probation. You have to pay a price. Fix this. Get out and make a responsible, exemplary life, not only for yourself, but for the children who you are going to be role modeling. You have to set an example, and you are able to be better. Do it. All right? That's my wish for you and your family. And again, these sentences shall run concurrently. Anything else?
That's it. That from the state, Judge.
Thank you, Judge.
Here.